Alongside the U.S. attacks that dislodged President Nicolas Maduro of Venezuela, American forces have for weeks been blockading U.S.-sanctioned vessels carrying Venezuela's oil. In the latest turn, the United States has begun boarding and seizing the so-called shadow fleet of tankers that move sanctioned oil across the globe, starting with stateless vessels. In a dramatic turn this week, the United States Coast Guard, with U.S. and allied military support, intercepted and boarded 2 Russian-flagged oil tankers in international waters, prompting protests from Moscow. Can the United States lawfully board and perhaps seize Russian-flagged vessels carrying Venezuelan oil? Does the answer to that question change if we assume the United States and Venezuela are still in an international armed conflict following the U.S. attacks of January 3rd? This is the Just Security Podcast. I'm your host, Tess Bridgman. Joining the show to unpack these issues and more is Rob McLaughlin. Rob is a professor at the Australian National Centre for Ocean Resources and Security and at the ANU College of Law, where he researches and teaches the law of the sea, maritime security law, and maritime law enforcement. He previously served as both a seaman officer and a legal officer in the Royal Australian Navy, including in senior roles such as Fleet Legal Officer, Strategic Legal Advisor, Director of Operations and International Law, and Director of the Naval Legal Service. He's the recent author of Blockading Venezuela, The International Law Consequences, published in Just Security in December, and Was the Visit and Seizure of the Skipper Off the Coast of Venezuela Lawful, published by Just Security, also in December. Rob, I can't think of a better person to discuss these issues with us, so thank you so much for joining us today. And perhaps to jump in, can you give us a recap of this naval blockade that the United States has instituted off the coast of Venezuela, purportedly for the limited purpose of preventing the transshipment of sanctioned Venezuelan oil? What does that blockade entail, and how would you describe its legality as an international law matter?
Well, first, thanks very much, Tess, for having me on. So the way to think about the blockade is we've got to look at 2 different bodies of law. The first body of law that relates to blockade is the law of naval warfare. So this is a blockade proper when you traditionally think about blockades, World War I, World War II, those sorts of things. However, to have a blockade under the law of naval warfare, you have to meet certain conditions, including notification conditions, setting out the parameters geographically of the blockade, and a bunch of other things. And in this case, it seems quite clear that this is not what the US has put in place in relation to Venezuela, because none of those conditions, with the exception of having enough units there to enforce the blockade, actually, that's about the only condition that you could say has been met in this situation. So in terms of it being a valid law of naval warfare blockade, the answer would be no for a range of reasons, which means that the validity of the blockade has to rest in what you might call the peacetime or the regular law of the sea. But of course, blockade's not something that the regular law of the sea contemplates, because you have the ability to control vessels in your national waters, and you have the ability to conduct maritime law enforcement, which we'll obviously talk about in a little bit. But you don't really have the ability to just, as a matter of, peacetime operations, blockade some other countries' coasts, or even set a limited regime in place in relation to things like oil, even to enforce something that is a domestic issue for the US in terms of the sanctions placed in the US domestic legal context over these vessels transshipping, or shipping rather, Venezuelan oil. So the only real parallel in the past to such a situation in the US would be the Cuban Missile Crisis, what was called the quarantine, where back then the lawyers involved were very particular to avoid the term blockade because of the connotations it had in terms of the law of naval warfare, and also illegality otherwise, or outside the context of the law of naval warfare. So it doesn't really meet the test of legality in that sense, either in terms of the law of naval warfare or in peacetime.
So if the blockade itself is lacking legal basis in international law, would you consider it a hostile act? Would you consider it a use of force, or something else entirely?
It certainly could. It certainly could cross the threshold in terms of a use of force, and in fact, as Mike and I have written previously on just security, imposing a blockade on another country in order to secure some political outcome is in fact, one of the definitions of aggression, the crime of aggression in accordance with the General Assembly's resolution back in the 70s. So in that sense, yeah, it's a pretty significant act.
So this blockade of sorts started several weeks ago, and the first tanker to be boarded and seized that you wrote about on our pages was ostensibly a stateless vessel. And it would be helpful, I think, if you can remind us what happened in that operation and why it may have been lawful from an international law perspective to go ahead and board that vessel, possibly even to seize it, despite the underlying lack of legal basis for the blockade itself. With respect to that first ship, the skipper, how did we get to, that one might be lawful as an international law matter?
Yeah, certainly. So I guess to go back to the fundamentals, so the basic rule when we're talking about peacetime or law enforcement, law of the sea governed maritime law enforcement, then the basic rule is that to board another state's flagged vessel, merchant vessel at sea, sovereign immune vessels, of course, are immune from any other jurisdiction, but to board another state's merchant vessel, merchant vessel that's flagged in another state, outside the territorial sea of any other state, is only available without consent in about 5 specific situations. To go through them very briefly and then to come back to the key one, right? The first is Article 110, the right of visit, and that's the one relevant to this situation with the skipper. The others are where you're enforcing your Article 111 right of hot pursuit, and that relates to that vessel having committed some offence in your territorial sea or your ports, for example, or your EZ, and you're pursuing it to arrest it in order to investigate that offence. The third option, where you don't need a flag state consent to board out in the high seas, is where there's a Security Council Chapter 7 resolution, such as the sanctions enforcement resolutions we saw against Iraq or Libya, for example. That also gives you the authority to board. The fourth is really a species of state consent, and it's where there's a pre-existing agreement with the flag state that if you make a request to board and they don't respond within a period of time, say 2 to 4 hours, you take that as a yes. That's really a species of consent, and that the US has about 12 of those sorts of agreements, ship boarding agreements. The tricky one is where the boarding's claimed in an Article 51 national self-defense issue, or as a response to some other breach, a wrongful act, right? But in that situation, what they're saying is we have committed a fundamental breach by boarding without flag state consent, but it is excused for this other reason. But that's not obviously relevant here. So the key one in this sense, in the skipper sense, is Article 110, the right of visit. And there are 5 reasons that you can board a foreign flag vessel on the high seas. And here by high seas, I mean outside the territorial sea of any state, without flag state consent. They are where you suspect it's involved in piracy, the slave trade, where you suspect it is involved in unauthorised broadcasting, where you suspect it's flying a false flag but is in fact of your own nationality, so registered to you, so in fact under your jurisdiction anyway. And the final one that's relevant in the skipper case is where you suspect the vessel is without nationality. So here, please.
Without nationality, which is the key one we'll focus on, there's been a lot of talk in the media about what could constitute piracy. Can you give us just the quick version of what piracy is and why that isn't what this is?
Yeah, so piracy is specifically defined in the Law of the Sea Convention in Article 101. This is clearly not piracy for a whole range of reasons. The key one is that sovereign immune vessels can't commit piracy by default. So, by definition, I'm sorry. So, the fact that the US Coast Guard did the boarding means it's not piracy, unless you asserted that the US Coast Guard team had gone rogue and mutinied and therefore become effectively pirates. That is certainly not the case.
It's our Coast Guard is not engaging in those kinds of rogue actions. Whether other U.S. actions considered rogue in the plane of international relations is another matter. But yes,
that's right.
We can rule out that this looked anything like piracy. So going back to the key stateless vessel, rationale for boarding. Can you talk us through what's required there, why that's permissible?
Yeah, so being a stateless vessel or a vessel without nationality, there's a couple of different types. The key type here, I think, is where the vessel claims a nationality to which it is not entitled. Now, in this case, in the skipper case, it appears on all the evidence we have thus far that the skipper was claiming the nationality of Guyana and was flying the Guyana flag. The US apparently has talked to the Guyana, the relevant authorities in Guyana. They've said, nope, we removed her registration, which means that she, in fact, has no flag, which therefore means she is a vessel without nationality, and therefore the boarding under the Article 110 right of visit was, in my view and my co-author's view, entirely lawful. The question then is, okay, what then? To what extent can we assert our domestic jurisdiction over this otherwise stateless vessel, in effect substituting US jurisdiction on board the vessel and over the vessel and the people in the vessel? That is a matter that's much more contentious in international law. My own view is, of course, as we expressed in that short article on just security, that of course you can assert some of your domestic jurisdiction as a substitute jurisdiction over that vessel. The extent to which you can go in doing that is the issue.
And would you estimate that seizing the cargo of that vessel, which was in this case, of course, Venezuelan oil, bringing it back to a domestic port and going through a process in your domestic courts to have that forfeited, would that be within the scope, you think, of the jurisdiction that can be exercised aboard a stateless vessel?
The literally $1 million question. As a matter of US domestic law, which I'm not an expert on, but it would appear that it is within jurisdiction. So the key international law question is the one you pointed out, is how wide can you take that scope once you are asserting your jurisdiction over that stateless vessel? How wide does that jurisdiction go? To my mind, it is clear that if something happens on board the vessel while you're in the boarding, let's say the crew of the vessel injures one of your boarding team, could you assert criminal jurisdiction over that for assault, for example? I think there is no question that you could and should do that. Whether you can then go the further step, as in this case, and take action against the vessel on the basis of other domestic legal sanctions put in place in this case, that's the $1 million question. In my view, you can go some way further than, yes, they've injured someone, one of my boarding team in the process, to assert other jurisdiction over the vessel, but the extent of that is really an open question.
Yeah. And one that I think we'll see states speaking to more if this pattern of conduct continues, which brings us to the more recent boardings. And, it's a pretty dramatic turn of events when oil tankers leave Venezuela without being flagged vessels or flagged under some other nationality or perhaps falsely flagged. But then, as the case is with the two most recent vessels, become Russian flagged vessels somewhere on their journey right across the high seas. And at least with the most recent boardings, it appears to be the case that the United States is still claiming that those vessels were stateless, right? Whereas Russia is saying, well, no, they were temporarily Russian flagged. On the other hand, not making too big a show of the fact that they were stopped, right? So one might expect perhaps louder protests from Moscow than we've even seen. They've, as far as has been reported thus far, demanded humane treatment of any Russian nationals aboard the vessels, demanded that they be returned expeditiously to Russia. It's not clear, though, the extent to which there's really a conflict with respect to whether there was, in fact, a violation of the law of the sea in the boarding of the vessel itself. So can you talk us through, if the vessel was, in fact, stateless? I assume it's the same scenario as we just discussed with the skipper. If the vessel was in fact Russian flagged, which there seems to be some dispute over, What are the lawful bases for boarding it? And how do we decide what in fact the case is with respect to whether it's Russian flagged or not? If there's a dispute over whether a vessel has been reflagged effectively, right? What are the criteria for that, and who determines the result of that dispute?
Yeah, key question, Tess. So, look, at the outset here, talking about this particular incident in terms of the law of the sea and maritime law enforcement. What does temporarily Russian flag mean? I have no idea. But
that makes
removing removing the temporary bit for a moment, it would appear to me, just on what's been reported this morning, my time, in relation to this, is that Russia is claiming the vessel is flagged in Russia, temporarily or not, I'm not sure. Is claiming the vessel is flagged in Russia. And if that is the case, then the law of the sea essentially provides that it has a nationality. So it's sort of, you can't be half stateless or have half a nationality. You're either flagged or you're not. You have a nationality or you're not, in terms of vessels. So I think the only way the US argument about it still being stateless would hold, or a vessel without nationality would hold water here, is if there is a suspicion that the vessel is still claiming two nationalities and using them interchangeably. This is where the temporary comes in. If they're saying, it's using Russian nationality today, but tomorrow it can go back to, nationality Y, then that would mean the vessel is effectively stateless again. Why? Because Article 92, Subarticle 2 of the Law of the Sea Convention says that if a vessel is using two or more nationalities interchangeably, then it can claim the protection of neither. I'm not sure that's the case here, unless we have information that it is, alternately using these different nationalities. So on the face of what we see so far, prima facie, you'd probably think the Russian nationality claim is effective. Your second part of the question, however, is really interesting as well, because you said, what are the conditions for this registration? How do we assess that? Well, in fact, the law of the sea is all about the flag state and its processes here. So the law of the sea convention basically says there has to be what's called a genuine link between the flag state and the vessel carrying that flag state's registration. But this has been routinely interpreted in international law and also by the International Tribunal of the Law of the Sea in a number of cases, including the Virginia G case and the Saiga case, two very famous ITLOS cases. Basically, so long as the vessel meets the registration requirements put in place by the flag state, the relevant flag state, Russia in this case, and the flag state does not deny or rescind the registration, as was the case with Guyana and the skipper, then the nationality claim is prima facie legitimate. So that's the start point to go from here. The genuine link argument is not a very powerful argument because it's been so watered down in terms of interpretation of international law over the last, 50 to 60 years.
So just to distill that, if Russia in this case has a genuine link to the vessel, which is determined by Russia saying it does, essentially, and at least not denying that it does, that's sufficient in the first instance for considering it to be a flagged vessel. And if that's the case, on what basis, does a dispute then get decided? So the United States may be claiming this alternate flagging scenario that you just talked us through. But if that doesn't hold, if that's not in fact the case, how do we proceed from here? Where does a dispute like this get adjudicated? Obviously, the United States is not a party to the UN Convention on the Law of the Sea. It recognizes the provisions that you've been discussing as customary international law, but that tribunal is not available, for this dispute. What happens next?
Yeah, so it really, as a quick sort of a hot take, I'd say there's really only two options. The first, or three. The first would be some form of arbitration, maybe through the PCIJ. The second would be an ICJ case. Neither of those is going to happen quickly, so they're not really an effective mechanism in this case. And of course, the US might legitimately argue that it's not going to accept ICJ's jurisdiction over this for some reason, as it has done in the past. And I say legitimately argue in terms of US view of the law, not necessarily in view of the international law. The most likely way it'd have to be resolved is diplomatic negotiation. I suspect that's what will have to happen, and much will depend on how the diplomats get together and talk about how they're going to resolve this.
So, to the extent there's another piece of this puzzle that then becomes relevant, which is that there's been some reporting that this vessel was being escorted by a Russian submarine. It's not clear whether it was actually present at the time of the boarding, but let's assume that some Russian military assets were present. How does that change things in your view? Obviously, it increases the possibility of escalation, right? You could have a very serious international incident on your hands if the United States and Russian military assets on the high seas are actually getting into a situation where there are hostilities taking place, hostile actions as between the two. Is there anything that we should factor into this analysis that changes if, in fact, you have that sovereign state who's claiming the vessel is flagged to their state present and, in fact, asserting that this vessel is subject to their jurisdiction?
So that's a tricky one. As a very fundamental or basic matter of the law of the sea and maritime law enforcement, let's assume for a moment, I'm not saying this is the case, but assume for a moment there was a valid US basis for the exercise of the maritime law enforcement power over this vessel. In that case, a Russian warship in the vicinity should not interfere because there's a valid exercise of maritime law enforcement power. There is not a valid basis for the exercise of the law enforcement power. That does raise a different issue, which is not necessarily a law of the sea issue, but a broader international law issue, and that is the right of a flag state's warships to protect their flagged merchant ships. Now, this has been an issue ongoing around, in different conflicts. So we've seen during the Iran-Iraq War, 1980, 1988, the US would protect merchant vessels going through the Straits of Hormuz, for example. So that's a function of national self-defense, of protecting your national shipping. But this is a point at which we then depart really from a law of the sea analysis, and you have to start stepping into broader international law analysis and thinking about Article 51 and protection of national assets and things like that. So that really is a difficult one to assess on the basis of the facts that we have at the moment, because we're departing from the maritime law enforcement context and starting to enter a whole different realm of international law. And I know that you and Ryan and Michael have written on this. The other thing I'd add, however, is that the ICJ in the oil platforms case, for example, which was in fact, an Iran-US issue during the Iran-Iraq War after Praying Mantis in 1988, has basically said that an attack, if we're thinking about the Article 51 analysis, an attack on a merchant vessel does not constitute an armed attack under such as to trigger Article 51. An attack on a warship, absolutely. Okay, although the ICJ was not definitive on this, I think it's generally considered that an armed attack on an attack on another state's warship crosses the threshold of an armed attack.
And for those who are familiar with Article 51, right, this is the provision of the UN Charter that allows states to exercise their inherent right of national or collective self-defense, right, if they have been subject to an armed attack. And so the point here being an armed attack against an attack on a warship would so constitute an armed attack, triggering that right of self-defense under Article 51. A merchant vessel doesn't give rise to that same conclusion that Article 51 is triggered, and therefore you can use force in self-defense. Absolutely.
So the challenge here, however, is that, again, as has already been written about on Just Security very eloquently, is that the Article 51 trigger, armed attack, and the international armed conflict trigger under the law of armed conflict are not the same. The same act may in fact not trigger one but trigger the other. And I think the analysis thus far on just security is right there that an act such as this might trigger or cross the Common Article 2 threshold, whereas it will not cross the Article 51 threshold. So that raises a whole different issue around whether there's actually an international armed conflict triggered. In my own view, it doesn't trigger an international armed conflict, but in many respects, the question is irrelevant because there's probably already an international armed conflict technically afoot between the US and Venezuela based on what has already happened. And that then, of course, raises the issue, well, was this boarding, in fact, a maritime law enforcement boarding governed by the law of the sea, or was it a boarding governed by the law of naval warfare, in which case there are a whole different set of criteria to meet.
You read my mind, Rob. That's exactly what I was going to ask you next. So, this whole blockade, which of course is not a lawfully justified blockade, began in December prior to U.S. operations, at least any overt U.S. operations using military force against Venezuela proper. Right. To remind folks, the United States since last September has been taking lethal strikes against suspected drug trafficking vessels, small go-fast boats in the Caribbean and the Eastern Pacific. Those were not ostensibly aimed at Venezuela as such, but aimed at the drugs and the drug traffickers and the drug boats themselves. And the United States claims, erroneously in my view, that it's in a non-international armed conflict with groups that are supplying those drugs to be ferried. Right. So that is separate from what followed vis-a-vis Venezuela proper, which is the blockade, and then the January 3rd attacks that were relatively extensive, that involved a huge contingent of, not only U.S. air power, but approximately 200 troops on the ground, right, that took military action in at least 3 different states, as well as in Caracas, killed approximately 80 people, Venezuelan and Cuban security forces included. In the firefight, there were probably about 7 U.S. casualties. And of course, most notoriously, President Nicolas Maduro and his wife were seized in their home and removed from the country, where they were then brought to the United States, where they're now standing trial in New York. That undoubtedly triggers an international armed conflict between the United States and Venezuela. The United States seems to be claiming that conflict is not ongoing to the extent they acknowledged it at all. And we are left, of course, with this question of what is the status of the relationship between that international armed conflict, right? The naval blockade that predated it, but now seems to have pretty close nexus to it. And of course, this most recent boarding and potential seizure of a vessel that has essentially escaped that blockade. So I guess 2 questions for you, Rob. The first is, in your view, is that nexus strong enough? Should we consider this part of that international armed conflict? And then 2, as you were just alluding to, right, the laws of naval warfare then kick in and the analysis changes quite dramatically. So first, I guess, is this part of that armed conflict, or at least is there a strong argument that it is? And if so, how does your analysis change based on flipping paradigms into the law of naval warfare?
Yeah, no, it's so.
Easy questions for you. Only the
Jess, I agree with your analysis on was there an IAC slant? Is there an IAC between Venezuela and US? There clearly was for a period of time. Is that IAC ongoing? That I don't know the answer to, and that's a really fundamental question about whether the US still has access to rights under the law of naval warfare in relation to neutral shipping, because that's what we're talking about here. What rights would the US have, if there is an IAC, what rights would the US have against neutral merchant vessels as a result of the application of the law of naval warfare?
And to be clear, talking about if it's a Russian flagged vessel,
yes,
Russia being
yes,
in the international armed conflict between the United States and Venezuela.
Correct. Now, in that situation, let's hypothetically assume that is the case. The IAC is ongoing. The law of naval warfare is applicable. Then the US would have the right to seize and even capture neutral merchant vessels in certain situations. One would be if it breached the blockade. The question then comes back to that one we first addressed: is the blockade valid? I don't think it is. So I don't think you've got a good basis there. The other would be, or an other would be a visit and search regime, which you might be able to make the argument is a valid exercise of a search, a visit and search power. This is different to the right of visit we talked about under the Law of the Sea Convention, under Article 110. The right to visit and search is a specific law of naval warfare power. You go on board, you search the documents to see if you think the vessel is carrying contraband. In this case, is there a contraband list? It's difficult to say because really contraband is generally about items susceptible for use in the armed conflict by your adversary going into their territory, not really stuff coming out. But let's put that aside for the moment and assume that there was a valid authority under the law of naval warfare to board this Russian-flagged neutral vessel because of some contravention which the US has the authority to act against in accordance with the law of naval warfare. Now, if that were the case, could it board that vessel? The answer is yes, it could. You'd have to explain what the basis is, and on the facts before us, I can't really ascertain that. I'm not quite sure, what the basis might have been in the law of naval warfare context. Very difficult also because, as you said, the US authorities have basically said it's not a law of naval warfare thing, it's a maritime law enforcement thing. So that's a bit trickier. If they had done that, however, what follows? Three things follow from that. The first is that the validity of that seizure or that capture, as it would be called in the law of naval warfare, would need to, because it's a neutral merchant vessel, would need to be assessed in a prize court. That is, the US would need to stand up a prize court, which the Supreme Court is obviously, and assess against prize law the validity of that capture. If it didn't do that and didn't have the capture validated by the prize court, then technically the vessel can't be condemned, as it's called, to US ownership. So what the prize court effectively does is it says, right, US forces, you've captured this vessel. It's a law of naval warfare context. Was the capture legitimate? Yes. We now condemn the vessel and, in many respects, its cargo to the ownership without compensation of the United States. That's how a prize court would need to look at
prize
this.
or no prize. And for interested listeners, that was a huge, huge percentage of the Supreme Court's early docket in our country.
Absolutely. The US Supreme Court was a major generator of the way that prize law evolved. So yes, they would be perfectly equipped to deal with this, but whether a prize docket would end up before the Supreme Court, very, very interesting question. And if it did, the Supreme Court would have to address all these issues you and I are talking about right now about the validity of the capture. Was it a law of naval warfare situation? Was there a contraband list? All these different things would need to be considered. So that's the first thing.
And in fact, whether we're in a situation where there is an international armed conflict. Yeah.
Correct. Because if there's not, then there is a narrow path for saying that prize and such seizures exists in a NIAC, a non-international armed conflict, but it's only where traditionally that NIAC is a recognition of belligerency situation. That's a much more complicated issue, so we don't need to go into that because I don't think there's any NIAC issues here, as you said. The second thing that would follow from that is that the crew of the captured neutral merchant vessel are not to be treated as criminals. They are to be treated as prisoners of war. The law of naval warfare and the law of armed conflict is absolutely clear on this. They either get treated as prisoners of war and held for the duration of the conflict and then repatriated in the normal course of events after the end of the conflict, or they are given what's called parole. We colloquially call parole, which means that they're simply repatriated to their home state. They are not treated as criminals and they're not charged with offences in that sense.
And that seems to be akin to what Russia is asking for, right? Treat them humanely and repatriate them. So it's unclear, obviously, whether Russia believes there is an international armed conflict. If it does believe that, whether it believes that there was an effective blockade, highly doubtful. If it did believe that, whether this visit and seizure were lawful, also probably doubtful. But if we got to all of those ifs, right, their behavior is actually consistent with that to this point.
Yeah, and the US could could say, no, we're going to make them PW, prisoners of war for the duration, or no, we're going to repatriate them. But the US would still be able to keep a number of the crew, navigator and the master of the vessel, for example, to provide evidence if required before the prize court proceedings. But then after that, they could then repatriate them if that was the path taken. The third issue, however, is a really interesting one here, and it comes back to your point about there being a Russian warship in the vicinity. This raises the issue of convoy. Now, in the law of naval warfare, a neutral merchant vessel under neutral warship convoy cannot be boarded, right? Is not subject to the right of visit and search, where the neutral warship provides the requisite guarantees to the combatant party, the US in this case, if we're talking about an IAC, that the vessel is not carrying any contraband material. And in that situation, the US would not have the authority to do a visit and search. But in this case, of course, we don't really know that the alleged Russian warship is in the area. So I don't think the law of convoy applies in this situation because, the warship wasn't even present. And there was no ability for the warship to make these assertions on behalf of the vessel carrying its nationality.
Russia perhaps being a bit overstretched with its own war of aggression. But I think there's also a lot of, no pun intended, uncharted waters here. As we've just been discussing, is there even an international armed conflict? Is there an effective blockade? Should the United States be in the business, of course, of boarding and seizing these vessels at all when its purported basis has really nothing to do with what we've been talking about thus far? So let's kind of put a pin in that for a moment. The United States is basically simply claiming stateless vessel U.S. sanctions, right? There's a shadow fleet that's taking sanctioned oil around the globe. That much is factually true. There is a shadow fleet that is doing that. To your knowledge and based on kind of what you've seen with this episode, is this consistent with how those kinds of shadow fleet ships, those vessels, would be treated if they were pursued, by law enforcement authorities? Is this how that works? What laws would govern in kind of taking any potential IAC with Venezuela off the table? We have a shadow fleet vessel that's carrying around sanctioned oil. How should that be treated? And how does the law of the sea treat that vessel?
Yeah. So really, the law of the sea has nothing particular to say about a vessel carrying oil that is sanctioned under a domestic regime. In fact, the freedom of navigation would, and the general rule, the default rule that you need flag state consent to board that vessel would apply. Now, if this oil sanctions were based in a UN Security Council Chapter 7 resolution, different issue, because that's one of those 5, situations where you can board without flag state consent. But there's no overarching Security Council Chapter 7 mandate for these sanctions. They're a US domestic law exercise. The European Union has done this as well in the past, but again, you've got to look to the UN basis of a set of sanctions to find a way to override the requirement to get flag state consent. What other ways might you get on board a shadow fleet vessel? Well, the best way, I guess, is the one we've talked about, which is if you can ascertain that the vessel is in fact a vessel without nationality based on the fact that it's flying a flag it's not entitled to, and the registry has been contacted and they said, no, we don't register that vessel anymore, or it's flying those two or more flags interchangeably and therefore can claim the protection of neither. That's your best option for the shadow fleet. The Finns, for example, is it the Finns or the Swedes, have detained a shadow fleet vessel for dragging an anchor and breaking cables in the Baltic. Again, that was legitimate based in the law of the sea, but the Finnish court, it was asserted as legitimate based on the law of the sea, but the Finnish court has now looked at that and said, no, we're not going to proceed with that for a range of reasons. So the shadow fleet's involved in a whole range of things, potentially launching UAVs against airports in Denmark, dragging their anchors to break cables in the Baltics, shipping sanctioned oil around. None of those acts really gets you anywhere under the law of the sea unless you can find one of these, either an Article 111 hot pursuit issue, which is much trickier because it means it has to have been in your jurisdiction at some stage, territorial sea, for example, or EZ, or you really need an Article 110 right of visit basis to do so.
Yeah. Well, this has been incredibly edifying, and the range of issues that we had to talk about to try to wrap our heads around this is a bit dizzying. So I really can reiterate, I can't think of a better person to have talked this over with us today. Look forward to reading what you next write about this as well, and hope to talk with you again in the near future as we see what happens next. I think your prediction is the same as my intuition on this, which is that this is going to get resolved in the diplomatic world, not in a court, at least not anytime in the near future. And we'll see essentially whether Russia backs down, right? What the response is of the Venezuelan authorities to the extent this continues happening, and the United States is continuing to threaten force against the current Venezuelan officials now that their head of state has been removed to the United States in that U.S. attack. It's obviously a very complicated geopolitical situation. But one where, the likelihood is that it does get resolved in that diplomatic realm, which unfortunately right now is also rife with coercion and threats of further uses of force. So our eyes will be on this set of issues, and we hope to get a chance to speak with you again soon.
Thank you very much, Tess, and to the Just Security team. It's been a great honour to be with you.
This episode was hosted by me, Tess Bridgman, and produced by Maya Neer and Pooja Shah. Special thanks to Rob McLaughlin. You can read all of Just Security's coverage on the seizure of vessels and the U.S. attacks on Venezuela on our website. If you enjoyed this episode, please give us a 5-star rating on Apple Podcasts or wherever you listen. Thank you.